Good afternoon, everyone. Thank you for taking time out of your day to join us for our Broker Series Legal Forum 2022 Year in Review. I am Justin Davidson, General Counsel and Director of Government Affairs. I'm joined, of course, today by Catherine Taylor, our Associate Counsel, and Johnny Schreiber, our Legislative and Regulatory Counsel. I was going to kick off our presentation today by reviewing the litigation, providing a litigation update on everything that is happening in the industry. Catherine's going to follow that up with some hot topics that we're hearing about on the legal hotline. Johnny will then share what we've been working on the advocacy side of things throughout this year, and also a look ahead to what we might be expecting in 2023. And then we'll wrap up with time permitting, some questions and answers for you all. So with that, I will jump right into the litigation update. And this is the antitrust litigation, which is NAR and 4 corporate defenders. They are defending 2 2019 seller class action lawsuits. The first one is out of Illinois, and the second one is the Sitzer case out of Missouri. They both have the same allegation, and that is the MLS rules requiring listing agents to offer buyer agent fees leads to artificially inflated fees, costs, and use of buyer representatives. They also allege that buyers should pay directly out of pocket rather than having the compensation flow through the transaction. And of course, they point out that the US system is anti-competitive because foreign markets without MLSs don't have buyer agents and pay less in broker fees. So if somebody else is doing something different, the US needs to follow suit, is their claim. The first one, as I mentioned, is the Illinois case. That's the Morrill case. And the claim is sellers who sold homes in 20 jurisdictions across the country. This doesn't include California and New York, which would have made it a much bigger class. This is still early in the case, and they are arguing for class certification. So that just means the plaintiff needs to argue that the named plaintiffs here, their situation is so similar to all others that it's best to handle it as a class. NAR, of course, has argued that every real estate transaction is unique and depends on the facts. You need to look at the entire transaction from start to finish to determine even if there is harm, and if so, what would it be? We don't expect trial in this case to come about until 2024, and that's if the plaintiffs are successful. The Sitzer case is a little bit further along and targets 4 Missouri MLSs. This one is headed to trial. Motions for summary judgment have been made, but we anticipate trial to start February 21st. There'll be a jury trial in Kansas City, Missouri. And while we do anticipate the trial will end by March 14th, I think regardless of the outcome, we'll see an appeal in this case. Both parties have too much invested in this to not appeal at this point. The next one I want to touch on is the Leader case. This is in 2021, there's a different group of class action attorneys that filed on behalf of buyers. So the other cases, they were filing on behalf of the seller. This has the same claims, rules, and allegations, but on behalf of buyers harmed indirectly. So their claim here is that the buyers didn't want to purchase buyer representation. They're trying to purchase a home, and the sellers increased the price of the home to cover the cost of hiring the buyer agent on their behalf. The Federal Antitrust Act, the Sherman Act, does not cover what are known as indirect purchasers. So the court dismissed the case and allowed the plaintiffs to amend. At this point, they have done so and are trying to base their claim now on a nationwide class based on 25 state laws that do allow indirect purchasers to bring lawsuits. NAR has filed what's viewed as a very winnable motion to dismiss because they have failed to allege a cause of action. We don't anticipate a decision on the motion to dismiss this year, so that will head into 2023. There always is a Massachusetts angle, and that is the No Select case. So just letting you all know that this is ongoing. There was an omnibus motion to dismiss that was denied in December of 2021. And this case, same allegations, and is going through the discovery process now. So that is each party looking for information that they think will help their case. I do want to touch briefly on the DOJ settlement. This goes back to, yeah, Catherine, you can skip up the slide. This goes back to the 2020 settlement with the DOJ. This might just be a review for all of you, but a good reminder that NAR and the DOJ, Department of Justice, entered into a consent decree that should have closed the DOJ's investigation down. It was filed with the DC District Court. NAR, of course, followed all the requirements of the consent decree. They agreed to change the 4 MLS rules that the DOJ had approved. However, the DOJ did not respond. And then, of course, there was a transfer of government. And in July of 2021, the DOJ indicated that they were not going to uphold their end of the deal, and they wanted to undo it to continue their investigation. NAR rightfully has argued that they cannot unilaterally withdraw from a contract, something I think all of us here are familiar with. And they've sued for injunctive relief to quash because NAR has already fulfilled their obligations. You can't have one party that is reasonably relying on an agreement and the other party back out. So that is currently pending, and we suspect that the court is probably waiting to see what happens with the class action lawsuits. NAR has a lot of great information available. You can see here, realestateCommissionFacts.com, and it talks about the value that paying buyer brokers brings and what would happen if that weren't the case. Here's a great list, but some of the important ones: we wouldn't have a centralized source of available homes for consumers or brokers. Consumers would have to go from brokerage to try and see the available homes. The information would not be updated as it is today. So some really key points that you can use when talking to clients, customers, anybody out there, or your own agents about the value of buyer brokers being paid through the transaction. There's also competition.realtor. Recommend you take a look at that. Really, again, helps in your discussions with your agents and clients. Wrap up with a couple of key takeaways. Remember, compensation is always negotiable. The broker cooperation is a benefit to consumers. I really want to flag this third point, that it really gives first-time homebuyers and low and middle income homebuyers a better shot at affording a home with professional representation that is so important when somebody's making the biggest investment likely in their lives to that point. So what can we as realtors do? Make sure you educate your clients and customers. I've said it a few times because it is important. And then end by reminding everybody to use buyer representation agreements. And here in Massachusetts, we're about to file an amicus brief in a case where a buyer representation agreement would have prevented this from ever moving forward. But what we have is an agent who didn't use the agreement and now needs to argue that the oral agreement exists, and it's on further appellate review by the Supreme Judicial Court in Massachusetts to try and determine how damages would even flow in such a situation. So I think the big reminder here is that use buyer agency agreements and avoid tens of thousands of dollars in litigation costs. So with that, I will turn it over to Catherine Taylor to touch on some of our hot legal issues.
Excellent. Thank you, Justin. You'll probably hear me say a few times throughout my spiel as well, a reminder to use those buyer agency agreements. They are important, and they're becoming ever more important with the changing marketplace. So what I'm going to do is take a little bit of time to cover some of the hot topics that we see coming through the legal hotline. These are based on actual questions that we received. So certainly would call these some trending issues. Every relationship you have begins with agency, and it's one of the top questions we always get is related to agency as a whole. As we know, there's designated agency, there's traditional agency, there's dual agencies, there's facilitation. So there's a lot of different angles that agency can take. You have to make sure that you are properly entering into that relationship with customers, clients, consumers. The big question that has been around for as long as this form has been around is, when does that mandatory licensee consumer relationship disclosure form need to be presented to a consumer? That's the long formal name for the agency disclosure, as people commonly refer to the form as. It's always stated it needs to be presented at that first personal meeting to discuss a specific property. That language led to questions about, what is a personal meeting? What if you don't have a personal meeting? Does it need to be used in commercial transactions? Does it need to be used in rental transactions? September of last year, they updated the form to help clarify some of those never-ending questions that we were getting. So now there is language that has been added that says, if there's no personal meeting, the form must be presented prior to entering into a contract with the consumer. That's prior to the licensee, you and your agents, entering into that contract with the consumer. It's always better to present it earlier in the relationship rather than, waiting until you're at that point necessarily. And you can always update it if your relationship changes. You can update the form to accurately reflect that. You could enter into a relationship as a facilitator and then upgrade into buyer or seller representation. You can never downgrade your relationship in the same transaction. So you can't go from an agent to a facilitator. It also clarified that it's only needed for residential transactions. This is just a screen grab of what the current form looks like. Highlighted is the new language. So please do make sure that you're using the updated form in your transaction packages. This is available in all of the forms libraries that you can get your MAR forms for. One of the questions that we've seen a huge uptick in over the last several months is, what relationship does a listing agent have with an unrepresented buyer? So the traditional scenario is you're hosting an open house, a buyer comes in and doesn't have an agent, and they want to put an offer in directly through the listing agent, which is perfectly appropriate. But there's a lot of confusion over how that listing agent can and should interact with that buyer. So you can work with that buyer simply as a customer. You still owe them the responsibility to present the property honestly and truthfully and accurately, and to make those disclosures of no material defects and to properly account for funds. Beyond that, you don't owe anything to that consumer. You would present that consumer your agency relationship form that says you are the seller's agent. The other option, of course, with proper consent and notice being provided, you could enter into dual agency, which of course sort of gives you the ability to work with both, but you have to remain neutral if there's a conflict between the parties. So you could do either of those options. What you cannot do was, there's a big misunderstanding over, you cannot act as a facilitator on behalf of the buyer and an agent on behalf of the seller. Facilitation is a non-agency relationship, so you can't be in both an agency relationship and a non-agency relationship in the same transaction. Of course, once you get past the relationship, you move into contracts. This is what's going to govern really the transaction from the beginning to the end. You've got your contract to purchase, and you've got your purchase and sales agreement. Obviously, some areas of the state go straight to purchase and sales agreement. The principles here still apply. One of the questions that we always get is, how do we know when a contract is binding? And a lot of that's going to depend on what the contract itself says. So, for example, the Massachusetts contract, the MAR contract to purchase Form 501 requires a deposit, that initial deposit, in order to bind that contract. Not all contracts require there to be a deposit or any sort of exchange of funds. What is required is consideration, which can oftentimes be money, but it can also be the mutual exchange of promises between the buyers and sellers to engage in that transaction. So make sure that you're aware of what the language is in the contracts that you're using in your transactions. Is a verbal contract enforceable? It is not. Of course, we have the statute of frauds that requires contracts governing the transfer of real property, which is real estate, to be in writing and signed by the parties in order to be enforceable. And of course, I would be remiss if I didn't mention the unauthorized practice of law. Unless you have a law degree, you need to be very careful to make sure that you are not engaging in the practice of law in your representation of your clients in real estate transactions. So if you're going to be modifying any language in the contract or adding additional terms and provisions, please make sure that you are working with an attorney to make sure that the language included is appropriate and accurate and that you are not placing yourself at risk. So of course, not everything goes smoothly, right? A lot of times deals fall apart, and they can fall apart for any number of possible reasons. And not all of the reasons are handled the same way as far as what the possible resolution are. So you really got two buckets. Either something happens with the buyer and the buyer chooses to walk away, or something happens with the seller and the seller wants to walk away from the deal. And how it's handled is very different depending on which side is trying to get out of the deal. Oftentimes, a buyer has a lot more options and ability to back out of a contract. They've got contingencies that they can rely on to back out of the contract and perhaps get their deposit funds back. But they also always have the opportunity to walk away from a deal and forfeit that deposit. So a buyer is never in a position where they're going to be forced to proceed with a contract and purchase that property. The seller, on the other hand, has more limited options available to them in most cases that would allow them to walk away from the contract without consequence. Finding suitable housing, for example, is a contingency that may allow them to. But if a seller just gets cold feet or wants to move forward with a more beneficial backup offer, they're probably going to find themselves in a difficult position, because if that buyer wants to enforce the contract, the buyer has the ability to go to the court and say, I want to enforce the terms of this contract. I want to sue for specific performance and make the seller sell me that property. And the courts have found that real estate is unique in its nature, and oftentimes financial award would not make that buyer whole, that really the only thing that can remedy the harm is to in fact allow them to purchase that property as agreed upon in the contract. So sellers have a much harder time walking away without consequence. Of course, the parties could always agree to mutually walk away from the contract. Even if there's not the protection of the contingency, they can always agree to do so, but no unilateral. So if a deal falls apart, there's money generally being held in an escrow account. And the question becomes, what happens to that money, or what happens if it's not clear who that money should go to, or there's some sort of dispute over how it should be dispersed. As the listing office, typically they're the ones who are holding these funds. And as an escrow agent, you remain neutral. You do not make the determination of who those funds should be released to. Those funds shouldn't be released until you have a mutual release signed by all of the parties, or you have a court order that directs the disbursement of those funds. The subsequent question to that is, well, can I remarket the property if there's disputed escrow funds? And I'm going to give you a lawyer answer here. I'm going to say maybe, because it's not always clear. And in this situation, it's always wise to counsel your client, your seller client, before placing property back on the market, to have them talk to their own attorney and make sure they're not placing themselves in legal jeopardy by doing so. If they move forward with a new buyer and go under contract with them, are they potentially going to be bound by two contracts? So it's not the question necessarily of whether there's money disputed in the escrow account, but whether the underlying contract is in dispute. If you've got a buyer who's trying to enforce that first contract, it's probably not a good idea to place that property back on the market. However, Your seller should be talking to their own attorney and then giving you an instruction as their agent of how they want to proceed. Just a quick refresher on escrow accounts, that only brokers are able to hold escrow funds, have their names on the escrow account, and be signatories on that account. So it doesn't necessarily have to only be the broker of record. You could have additional signatories on the account that are brokers within the same office, but you cannot have an unlicensed individual, such as your bookkeeper or a salesperson within your office on that escrow account. Any funds that you receive during the pendency of a transaction have to be immediately deposited into that account, unless otherwise agreed upon by the parties. Sometimes there might be an agreement otherwise as far as who is going to hold the funds or how those are going to be handled, but the way the regulations read, has to be immediately deposited. So no waiting until after that inspection occurs, no, having it sit on your car dashboard. You got to get that deposited straight away. Of course, you have to maintain a proper accounting of all funds that you're holding in your escrow account and maintain those records for 3 years. Another question that we get a lot has to do with payments from brokers. Who can you pay? When can you pay? How can you pay? And of course, this brings us to the conversation on LLCs. Most commonly, it comes up with LLCs, but certainly could be any corporate entity. Oftentimes we get the question of, I've got a salesperson in my office, their accountant told them to set up an LLC to receive their commission payments. Can I pay that LLC? And unfortunately, the answer to that is no. Well, from a tax perspective, it is more beneficial for people. The licensing laws in Massachusetts do not allow payment to that LLC, because an LLC or S Corp or C Corp or whatever corporate entity is receiving the payment must also be licensed. The way the Massachusetts licensing laws read is only brokers. So one of the principles of that LLC has to be a broker in order for that LLC or other corporation to receive a license. So unfortunately, that is not an option that's available to salespeople. So if you've got associate brokers within your office, they can be paid through an LLC, but that is not an option available to salespersons. Referral fees is another big question, and always remember that any types of fees and payments are governed by the brokers who are involved in the transactions. So a salesperson cannot bind their broker to pay a referral fee. Referral fees may only be paid directly to other brokers, whether they have an active or an inactive license, or you can pay them directly to somebody who has an inactive license, even if they're a salesperson. When you have an inactive license, you can only engage in referral business. For all other purposes, you are considered unlicensed. There's no standard referral fee. It is completely governed by agreement between those brokers. We have a form for it, 521. If you don't use that form, do make sure you get it in writing so that at the time of closing, there's no confusion over what is due to whom. And with that, I'm going to pass it over to Johnny.
Thanks, Catherine. So I'm here to give you a little bit of an update on some of the things we've been working on the advocacy front, starting with a look back at the 2021-22 legislative session. If we can move to the next slide. So Massachusetts, we have 2-year legislative sessions. So we are in the second year of a 2-year session. Which was a great success. We saw a significant funding increase in a lot of housing assistance line items. They're broken down for you. These are various programs that help folks to be able to afford housing. And you can see really significant increases in most of the line items. A lot of that is kind of born out of the state filling in where the federal government had been contributing really large sums of money because of COVID impacts. And that money's basically been run through. And so now the state is stepping up to fill in some of those gaps. The funding levels of the state, while significant increases over what the state had funded before, are still below where the federal government was. So it'll be interesting to see kind of where all that shakes out in coming years. We successfully defeated transfer taxes, rent control, tenants' opportunity to purchase, or also known as right of first refusal, and more proposals. Things like mandatory home energy scoring is one you may have heard about. So we provided pushback on those. And most recently, you may have seen the legislature belatedly passed an economic development bill. They were not able to get through that at the end of formal session, which ended at the end of July, but they continued to work on it, brought it back, and were able to get completion right before election day today. So it includes $450 million for housing and related services, things like broadband, supportive housing. And there's also a really interesting policy piece in there, which makes a tweak to the existing starter home zoning district law, which allows for smaller homes to be built on smaller lots, which will provide the ideal types of housing that Massachusetts really needs, kind of that the missing middle housing, if you will, for people, for first-time home buyers, workforce members, maybe seniors who want to be able to age in their community. And by making the tweak that this bill would to this law, will allow hopefully more of those homes to be built. The bill was passed by the legislature and is currently pending before the governor. And so I also wanted to kind of do an issue dive on a single issue, one that you've likely heard a lot about, to help clarify kind of where things stand, how we talk about it, to help you be able to answer questions should you get them, and to give you a heads up, because this is an issue that we think we're likely to hear more about in coming days, weeks, and months. The city of Boston is poised to release a rent control or rent stabilization plan, and that's likely going to generate a lot of headlines in the state, and I think put significant pressure on the legislature and the new governor to take action. So these are things that we're already, looking into and planning for, and wanted you to know what's going on. So very basic. So what is rent control? It's a cap on rents. Why are rents really high? Well, we have a severe housing shortage in Massachusetts, and wages haven't kept up with costs. They haven't kept up with cost of housing, just like they haven't kept up with really the cost of anything, health insurance, groceries, you name it, right? How does rent control help? Well, it really doesn't. We can move to the next slide. So another thing that you'll likely hear about, and I already sort of hinted at, is this, we have rent control, that's sort of old school, and now we have this new school term, rent stabilization. And what's the difference? Well, there really is no difference. They are both versions of controls on rent, but sort of the classical old school fashion is this flat cap on rents. For example, in Minnesota, you can only raise rents 3% each year. So that would be sort of rent control. And then rent stabilization policies tend to be more like a cap on the consumer price index. So there's a percentage increase each year, and then plus an additional percentage. And then you sort of add those two together, it changes each year. And because it's tied to CPI, that will change as well. And that's your rent cap. So Oregon is the example of that. Next slide. So rent control impacts, there's been a lot of academic studies on rent control. It's been tried other places. It's been tried in Massachusetts. And pretty much every study and every economist agrees that these are the things that happen when you have rent control. So there's less multifamily housing available because current multifamily housing gets taken off the market. Some of it is converted to condos. So you have gentrification, which is the opposite of what rent control is trying to have happen. You have others that end up getting taken off the market because buildings go into disrepair. Landlords aren't able to continue to invest at the same level because their profits are being capped by rent control. And there's a disincentive to build because building values are decreased due to the cap on rents. And so there's very little multifamily housing that gets built. It also has kind of a perverse incentive in that it incentivizes landlords to raise the rents to the maximum amount that the cap/market will allow. Because you never know when you're going to have a downturn. And so you need to maximize the amount of money you can when you can get it. So whereas if you have a 3% cap, without the 3% cap, maybe you'd go a 1% or a 2% increase annually. If you think the market can bear a 3% increase and your cap is 3%, well, you're going to go for that every time to cover yourself when there's a down year, because you won't be able to come back if you lose 5% to then have a 5% increase in rent, right? This decreases property tax revenue for municipalities, and there's some evidence that it causes disparate impacts on folks who are renters and your mom and pop landlords. Next slide, please. So we decided to do a little bit of a deep dive on what this would look like, right? So Boston, from what we've heard, is interested in these sort of rent stabilization type policies. And specifically in Oregon. Oregon passed rent stabilization. It kicked in March of 2019. And their policy is the consumer price index plus 7%, which is a pretty high cap. So in 2022, that was just under 10%. And in 2023, that'll be almost 15% as your cap. Now, if you look at sort of the data over time, you look at the last several years, there's nowhere near those rent increases. Your average is about 2.5% in Boston and about 2.1% in Portland. Next slide, please. So let's look a little deeper and think about kind of where these policies are coming from, right? If they're especially for Boston, which is newly considering this. So Boston and Portland are really similar cities. They're similar in population, similar in median income. Boston, a little bigger, a little higher median income. But there's a couple of big differences. One is there's a significant proportion of renters in Boston, 65% compared to 45% in Portland. And another piece to look at, and you can see it reflected in the graph on the right, is the COVID impacts. And the American Rescue Plan doled out funds in part based on how communities were impacted by COVID. And you can see that Boston received 12% more funds than Portland did. And you can see, by this slide on the right, the instability reflected in the Boston market compared to the relative stability reflected in the Portland market. So, is that because of rent control in Portland? Did that sort of keep the rents more stable? And the answer to that is very likely no. So if you look at the pre-COVID numbers, Boston was even more steady than Portland, right? So Boston essentially flatlined at 0.1% increase annually year over year. If you look at September, which is when most rents turn over in Boston, compared to Portland, which was closer to 2%. Then since the start of COVID, Boston has seen a significant rise at over 5%. Whereas Portland has seen a much smaller one, now inching closer to a little over 2%. So we'll go to the next slide. But if you really dig into the Portland numbers, you see that they're not that simple, right? And so it's not just sort of a 2% gradual increase or a continuation of the 2% they had before. But what actually happened is, if you look at the right side of the chart at the top of the page, is that we had COVID, right? So that hits in early 2020. We have the dip into 2021. And while other places are, staying relatively flat or had been increasing during that time, we see from 2021 into 2022 that rent in Portland spiked 9%. And you'll recall that in the prior slide, I had said that academics say that the goal when you have rent control is always to push as much towards rent control cap as the market will bear. And that I laid out before, that Portland's cap was 9.9%. So year over year, we see a 9% spike, right? Which is exactly what you would expect from rent control. And then another piece of data that we looked at is multifamily housing. And I said that, academics say multifamily housing gets pulled from the market, and a very little new housing gets built because you've undermined the value of multifamily housing. And so we compared Boston to Portland in housing permits. So prior to, if the reason why 2019 is the date here is because that's when Oregon instituted rent control. And so we have Boston and Portland compared 2014 to 2018, and then looked at those numbers from 2019 to 2021. In that period, Boston increased 22%, while Portland dropped 4%. So, and that's, including the sort of greater COVID impacts happening in Boston. So again, just, the data playing itself out of what we would expect to see, multifamily housing, significant drop in Portland, largely due to rent control. So next slide. So what happens next with this policy? So rent control remains illegal. That's driven by a 1994 ballot question, but the legislature has the power to overturn that, as well as potentially citizens, should it be put to a ballot that would potentially be in 2024 or some later point. We've got a new legislative session in 2023 and 24. We've got we definitely have a new governor, and that governor is very likely to be Maura Healey, who has already said that she supports local option rent control. And as I mentioned before, the Boston bill is going to bring a lot of increased scrutiny and interest in this issue. So one of the big things that we can do to help with this issue is to support local zoning reforms. A couple were passed by the legislature with our support a couple of years ago. Housing Choices, which changes local voting thresholds for certain zoning issues from a 2/3 supermajority to a 50+1% simple majority, and MBTA communities, which you may have seen headlines about various communities trying to opt out of it. It requires slightly greater density of housing around transit to try to kind of create more vibrant downtowns that will allow for more people to be located close to MBTA lines. And with policies like that, the greater support that we can provide to them will create the housing that we need and remove some of the pressure on the governor, on legislators to consider bad policies like transfer taxes, like rent control, like tenants' right of first refusal, right? And MBTA communities is one where we're inching up closer to deadlines now. Communities have until the end of January in 2023 to provide their plans. So a lot of the plans and sort of the politics of it are getting hashed out right now in your communities. So getting involved to support that will go a huge way in helping to prevent bad policies. So that's my presentation. I'll turn it back over to Catherine, Justin, and all of you for questions.
Thank you, Johnny and Catherine. Looks like, Catherine, we do have two questions in the queue here. First is a form number for the updated form. And I think that was the agency disclosure form.
It does not have a form number associated with it because it's not an MAR developed form. If you go into the form library, don't look under agency disclosure, look under Massachusetts mandatory consumer licensee relationship disclosure. It's under the formal full name. It is in there, I promise. But it's just in alphabetical order, no number.
And a question about wiring commissions into bank accounts, sending them through different companies, and maybe the party's not comfortable with that. How do you handle requests like that? How do you advise members to handle requests like that?
It's entirely brokerage preference of whether you're comfortable using a different platform or wiring commission funds, or whether you'd rather send a nice old-fashioned check. Certainly, that's not dictated by the law. You're just required to pay them the offer that was made in a timely fashion. But how that's accomplished, if it's done other than through a check, would be through agreement.
I think a good reminder for everyone here is that anytime you see wiring instructions change, particularly by email, make sure you are following up on those and confirming them over the phone and not just accepting the changed instructions. All right, any other questions? All right, well, not seeing anyone, and I guess that's because Johnny, Catherine, you covered everything so well today. I do appreciate, again, all of you taking time to sit in with us today, and If you ever have any questions, reach out to Catherine on the legal hotline. Anything legislative, reach out to Johnny. Always available for your questions. So once again, thank you all.